早晨咁多位。
Good morning, everybody. It's the appointed time for the meeting, and we also have a quorum. We can get started. Could we please now ask the deputations and the individuals to come in? This meeting will last till 12 noon. In the first part, we are going to listen to the views of deputations and individuals. This is about the Property Management Services Bill.
We'd
like to welcome the administration as well. First of all, I'd like to call upon the deputations and individuals to speak. But if you'd like to use the earpiece, I'd like to tell you that channel 0 is the floor, channel 1 is Chinese, Cantonese, channel 2 is English, and channel 3 is Putonghua. If you'd like to tune in to the channels, please choose accordingly. I'd also like to remind deputations and individuals that your remarks at this meeting are not covered or exempted by the Legislative Council Powers and Privileges Ordinance Cap 382 of the laws of Hong Kong. By the same token, the written submissions you forward to us will not be covered or exempted by that ordinance either. So please, deputations and individuals, pay attention to that. I'd also like to remind deputations and individuals that you please avail yourself to the note on attending meetings in the chamber or other venues. And also there is a note for people in the public gallery. This is about our various security measures. A copy of that note has been issued to you in the letter from the Secretariat. It is also tabled for your information. I also like to remind members of the public in the public gallery. Now, if you'd like to know the details of this note, please get a copy from the security staff. These are the security requirements. Some deputations and individuals have given us their submissions. Now you will have 3 minutes at this meeting to speak. Please make the best use of the time allotted to you. And if you have not given us any written submission, please do leave a copy with us after the meeting. You can send a copy to the Secretariat. Thank you. So let's get started. First one, Mr. Alvin Young. Thank you, Chairman. I represent the Civic Party. Today we are talking about the Property Management Services Bill, but we cannot look at the bill in isolation. We must set the bill in the bigger context. By that we mean the Property Management Ordinance, or CAP 344. There are many stakeholders in the room today. They may be from the industry, but many more are from organizations or victimized owners' organizations. I think it will be better for them to speak up than for civic or parties, political parties like us. Political parties are here to talk about the system. Chairman, our proposal is that for a very long time now, we have had loopholes or questions within the ordinance, CAP 344, and we'd like to make some proposals about those. We can see that over the years, we have seen good property management done, but many more owners have been heavily victimized. This is because the PMCs have not been professional and they do not have enough manpower. However, they accept jobs indiscriminately. Our proposal is that we should professionalize the entire industry. And how should we do it? I think the best way or only way indeed is to license the PMCs. And of course, it's not just a piece of paper. You have to add conditions to that license. For example, we have to ask them to disclose their links or relationship to property developers, and owners will be able to do a so-called beauty pageant amongst the PMCs. They will know the background of the PMCs, and also if there is a license, you know whether demerit points have been recorded against a PMC. And secondly, the PMPs, we like to professionalize them as well, so we can enhance the quality of the entire industry. And then, of course, the PMSA, it must not be a toothless tiger. There must be a demerit point system. There must be the power to revoke a license, and also the power to mete out penalties. Now, maybe the owners have to pay a little more, but if you can enhance the quality of the entire industry and minimize the need for unnecessary arguments, I think the owners sitting behind me will bear out this point. And I'm sure small owners will be happy to pay just a little bit more so we can have assured quality of property management so that we can really have a harmonious society. Thank you. Okay. Next, Ms. Amy Young. Thank you, Chairman, and I thank members for giving me the opportunity to speak on the Property Management Services Bill. I'm a member from the Discovery Bay area, and I support the bill. In particular, that PMCs and PMPs are to be licensed. And also, Part 4 of the bill has to do with the responsibility of PMCs to provide information, and Part 5 has to do with the PMSA's power to conduct investigations upon receipt of material complaint from members of the public. I now like to talk about the scope and definition under the bill. Part 1, interpretation. A PMP is defined as a person who assumes a managerial or supervisory role in a property management company. I feel that this definition is too narrow. It only focuses on the internal command structure of the PMC and not the role of the PMP vis-à-vis the owners. It is important that the definition of PMP not be restricted to the top management, and that a broader range of persons responsible for providing management services be brought under the licensing regime. I suggest that the definition be expanded to include any person who is designated to represent the manager. For example, in Discovery Bay, Each subdeed of mutual covenant specifies the procedures for electing owners' committees for the relevant phase of the state and for holding meetings of such committees. The sub-DMC state that the manager may appoint a representative to attend and participate in these owners' meetings. I consider it very important that any person appointed as the representative of the manager to such meetings be a licensed PMP. In the interest of fair elections and the provision of professional management services to owners. Part 3. Publication of list of licensees. I suggest that a PMC be required to post and maintain an up-to-date record of all PMPs assigned to the state, specifying whether the licensed individual is a PMP Tier 1 or PMP Tier 2 at a prominent and accessible place within the building. This should be in addition to any power of the authority to publish lists of licensed PMCs and PMPs. Part 4. Duties of licensees. I appreciate the decision to require PMCs to disclose certain information. However, I'm concerned that the term client is not defined. I suggest that the term client be replaced by the term owners, and that any owner should have access to the information to be provided. Clients should not be restricted to the Owners Committee. In the case of Discovery Bay, the Owners Committee is dominated by the developer and the manager, as they control the majority of shares under the deed of mutual covenant. Under the circumstances, owners do not have the chance to speak up. Okay, your time is up. If you have more views, please submit them in a written submission. Next, Mr. Alice Ip Chi Ming. Good morning, Chairman, and good morning, members. I'm from the Hong Kong Institute of Housing. We support the proposed licensing scheme, especially the two-tier system for PMPs. The Institute agrees that there should be a two-tier system, and we should do this on the basis of academic qualification and also relevant experience, because managers have to be responsible for decisions. Therefore, the criterion for a Tier 1 license should be at a higher level than those for Tier 2. As for the bill itself, I'd like to make the following views. The bill should define clearly which are professional bodies, and also newcomers to the trade with less than 3 years experience. We hope they should not need to apply for a personal license because they do not have a lot of experience in the job and they are not in a supervisory role. And number 3, the government should subsidize tertiary institutes in providing further studies in professional property management, so people in the trade can enhance themselves, and also this will be an incentive for people to join the trade because in fact we have a high wastage rate and we need a lot of people in the trade. And also we believe that the PMP license should not be more expensive than $1,000 in annual licensing fee. By enhancing their professional level, we do not want to add to their financial burden. And also about the PMSA and also the appeal tribunal, we believe there should be more representatives from the trade, especially in the appeal tribunal. We have to make sure that the complainant has sufficient justification and also evidence in lodging a complaint, and there would not be a necessary burden given to the appeal tribunal, or else industry practitioners would be disturbed by vexatious complaints and they leave the industry, then we will have an even more severe shortage of manpower. The PMSA and the appeal tribunal could be set up by making reference to other professional supervisory bodies like the Medical Council, the discipline group in the Hong Kong ICPA, and also the Council of the Bar Association. There should be 4 or more people from the trade in both bodies so that there will be a deep understanding of the issues and there will be a fair treatment of the complaints. 覺得呢
好多呢個資深從業員呢係以前係默默工作嘅。我哋希望呢係高級嘅主管級嘅人員呢，同埋一個有資歷嘅從業員呢，係一次性嘅批准佢哋永久攞到呢個物業。好啦，時間第一級牌照。時間到啦，咁跟住下一位陳志球博士。
多謝主席。本人係代表房屋經理註冊管理局嘅，我係註冊管理局嘅主席嚇。咁房屋經理註冊管理局咧係按香港法例第550章嗰個房屋經理註冊條例喺4月1號2000年4月1號成立嘅，係一個法人嘅團體啦。咁專責咧係處理香港嘅專業房屋經理嘅註冊事務，同埋咧係負責監管註冊專業房屋經理嘅紀律嘅。咁就管理局咧而家係由唔少於16位成員組成嘅，咁就亦都當中咧亦都有唔少於2位成員咧係由行政長官咧係委任嘅。咁房屋經理註冊管理局咧成立到現時咧就係亦都係積極按照法例釐定嘅註冊資格啦，係將一啲合條件嘅人士咧係納入嗰個註冊裏邊嘅。咁管理局咧係對呢個發牌嘅制度咧特別係物業管理服務條例草案咧，就我哋係表示支持嘅。咁我哋咧亦都係有以下咧係有4點我哋希望咧就提出我哋嘅意見。咁就我哋希望咧就係喺房屋經理註冊管理局已經登記同埋現存記錄冊嘅註冊專業房屋事務經理咧，係可以自動成為擁有物業管理人第1級牌照，因為佢哋咧係經過嚴格嘅訓練亦都係經過一啲即係考核啦，咁然後攞取到一個專業資格嘅。第2點呢，就係我哋希望物業管理監管局喺定明物業管理人第1級牌照嘅時候呢，係需要一啲比較高嘅標準呢嚟到去釐定嘅，以係符合一個一個專業嘅標準啦。而對於物業管理人第2級牌照嘅資格呢，就我哋認為就可以較第1級嘅略為低啦，令到呢可以顧及到即係喺行內呢已經係有相當經驗。
So that people who have the experience can actually move up to a higher qualification. And thirdly, we hope that the PMSA to be set up in the future will include people who are familiar with the industry, and also the members of the appeal board and the tribunal should also be appointed, bearing in mind those factors. And in appointing members to the PMSA, I hope those who have been seasoned, experienced members of the Housing Management Administration Board will also be appointed. Thank you. Next, Mr. Ivan Tam from the. Thank you, Chairman. Good morning. I'm Tam Kwok Wing. I represent the Hong Kong Association of Property Managers Companies. I'm honored to represent our association to make our submissions regarding the Property Management Services Bill. The bill will help enhance the professional standard of the industry, and we are in support of the proposals in the bill, and we have the following submissions. First of all, we are the largest and the most recognized in the industry, and together with our subsidiaries, we have about 300 property management companies. We make up almost a third of the property management companies in Hong Kong, managing more than 70% of private residential units. Take residential properties, for example. We are managing close to 1,000 properties. And since the threshold for joining the association is not very high, and we propose that the threshold for admission to become PMC should be similar to the admission criteria for our society, so the members of our society will automatically be able to obtain the license, and also it will cater for it will also ensure that other PMCs will also be able to obtain licenses. We're not trying to exclude the smaller PMCs so that they will be eliminated. On the other hand, for those companies which are not yet eligible to be licensed, actually it would mean that their experience and the standard still has room for improvement. For example, for those PMCs which are managing one or two building blocks, should they be awarded licenses? And for comparing, I think the requirements for PMCs managing a few blocks and a large number of residential buildings are not the same. So we should ensure that the properties of different scale will be managed by the relevant PMCs with relevant experience. Right now, we have many buildings which are managed by small PMCs. I hope the government will come up with a comprehensive plan and come up with transitional arrangements to ensure that there will be minimum impact on the residents. And thirdly, in future, the members of the PMSC will comprise of three categories of persons. We propose that the members of the PMSA should comprise of representatives from our association. Thank you. Next, we have Dr. Fong Kok Hong. Thank you. Good morning. I represent the Greater China Institute of Property Management. And regarding the content of the bill, we support the proposal in principle. We agree that we need to enhance the overall property management standard and also enhance the regulation of the practitioners so that we can enhance the standard for the industry, for the profession. However, if only for the service providers and if only regulated practitioners and the PMCs without addressing the problems facing the industry is not really an effective solution to the problem, and it will not effectively resolve the various problems faced by the property management industry. We all know that the property management services agents are agents of the owners. They don't have any real powers. Very often the owners would require the PMCs and the staff to, in the course of the daily management duties, follow the instructions of the owners, resulting in some unfair practices and even breaches of law. Once the PMCs object to the owners or the members of the owners incorporation, they will terminate the contract of the PMCs and engage other PMCs what are willing to work, follow the orders of the owners incorporation. And I think this is the problem is particularly obvious for residential estates and industrial buildings. Some owners are involved excessively in the work of property management and very often resulting in conflicts, differences of opinion, and also owners being non-professionals interfering with the work of the professional property managers. And the owners very often will interfere with the work of the PMCs, and as a result, resulting in unprofessional practices. The PMC, being agents, are not able to fully protect the rights of all the owners, resulting in many problems. For example, the PMCs, there are very few people who are willing to join the PMCs because very often they are being scolded by the owners. I think in the bill, the administration should also regulate the owners' corporations and the owners as well, so that the property management industry will be able to develop in a healthy manner. Regarding the bill, we have two suggestions. Basically, we support the proposal for a two-tier registration or licensing system. However, in order that practitioners can provide service professionally to their clients, then they can only be licensed after they've taken a professional property management course. We also propose that the PMCs and the PMP can, in respect of the unreasonable acts on the part of owners, complain to the PMSA, and the PMSA, like similar to the practice of the Consumer Council, can also, issue circulars reprimanding those owners accordingly. Mr. Wong Kem Tong. Thank you, Chairman. I represent the Fung Hua Estate Incorporated Owners. I'm the chairman of the incorporated owners of that estate. Starting from 2011, I've been the chairman of the incorporated owners of the Fung Hua Estate. Since I became the chairman and until now, I have found that some PMCs, integrity leaves a lot to be desired. And even now, regarding the funds of our estate, the previous PMC have still not been able to give us a clear account. And we now need to engage accountants to help us, verify the accounts for that reason. I am very much in favor of PMCs should be registered and licensed. With a licensing system in place, the integrity and the standard and experience of those working in the PMC could be enhanced. I personally have 6 proposals. First of all, those who are PMPs including those at the manager and supervisor level, should be licensed. Regarding the proposal for a 2-tier licensing regime, it would depend on the experience and the integrity of the persons concerned. Secondly, we need to stringently, vet the licenses of the applicants. If the person applies for a license, we have to ensure that he has the capabilities to take up that position. Who is to decide whether or not he is the fit and proper person to become the property management manager, whether or not he has the ability to take up that post. And thirdly, at the time of licensing, we hope that the PMPs, we want to ensure whether or not they have any previous criminal records. Fourthly, we need to set up a complaints division to assist owners who can complain if they think that there are many, unreasonable, practices on the part of the PMCs. I have, for example, sought to obtain a fair and just, a solution to problems which occur in our estate. I think there should be a proper penalty system. And finally, I hope that we can organize a meeting at the district level so that members of OCs can actually, sit together and share the experiences. Next, Mr. Lau Ming Sum. Yes, you may proceed. Chairman, the first thing I'd like to say is that we have now eventually seen the light at the end of the tunnel. I am the chairman of the incorporated owners of an estate in Tai Kok Tsui, our incorporated owners of the Futor Loi Sun Chun. I think we set up the incorporated owners from 96-97. It's been 20 years since, and I have been since 2005. We have been managing our own estate. I believe I am the person who has actually been participated in the most number of litigations against PMCs, and in the course of which I have learned a lot about the PMCs. In 2005 and 2006, I have discovered that the PMC that actually were exploiting our staff. And I reported this to the authorities, and the person in the PMC subsequently was imprisoned for 8 months. More than 10 years ago, I was already saying or asking, why is it the government would not enact a legislation to regulate the PMCs so that we can have a supervisory regime, as a result of which the PMCs can work and operate according to that system. Because the OCs like a blank sheet of paper. The members don't know anything. The PMC, even the PMB have to apply for a license, and I'm sure the PMC, they would know, they're very clear about the laws. But however, for members for the OCs, I think you have to ensure that you have to ensure that the owners can participate. Sometimes the owners in corporation can be accomplice in many illegal acts. I'm very happy that I have the opportunity to attend the hearing today, and I'm very proud because more than 10 years ago, I was already advocating this proposal, and now that we have the bill, which will actually help me achieve my goal. So I'm seeing, the light at the end of the tunnel. Actually, I'm planning to retire in the next few years. Today, I think if this proposal for the regulatory regime can be implemented, then I'm sure I can retire and have fun with my grandchildren. Today we have this very good opportunity, and I think this will be for the good of all the owners, and it will also ensure that the professional PMCs will give us, good property management service.
Next one, Mr. Kandru Leung. Yes, I represent the Royal Institution of Chartered Surveyors, Hong Kong. We support and agree to such a licensing scheme, which will cover both companies and practitioners. The institution would like to speak on 3 aspects. Part 3, the DMC and also the PMC. I hope the BC will act with care because there will be a transitional period. Then there may be an impact on the enforcement of the DMC by the PMC during the transitional period. And then part 5, we support that there should be a disciplinary and also appeal mechanism. There may be unreasonable or vexatious complaints, which may be of a great number in future. Maybe there will be a deposit system so that we can avert unreasonable complaints, and also there should be an appeal mechanism. And then Schedule 4, ever since we have had the statutory minimum wage, we have a big shortage of manpower. And I hope the licensing system will help to prevent wastage, whether it be big or small PMCs. We can see that manpower is very tight. In order for small companies to survive, the government must think about preventing wastage. We hope the licensing system will not bring about a wastage of manpower. I believe the standard working hours may be another consideration. Thank you. Next, Dr. Eric Channon. I represent the industry. I'm from the Hong Kong Institute of Facility Management Limited. I'm the Director of Corporate Affairs. We are of the view that the bill can provide a framework for effective and long-term professional development of the industry. So we strongly support the proposals in the bill. Actually, on the 18th of July, we wrote to the Bills Committee and we submitted a paper of 4 pages making different proposals on the bill. We are aware that there is no detailed eligibility criteria for PMP license and the detailed procedures and rules on disciplinary actions. This might lead to the feeling of insecurity by some practitioners, as stated in our submission. However, if the criteria are too detailed and specific, the system may be too rigid. Therefore, we'd like to make a proposal in order to strike a balance. First, we believe the administration should provide information on training and bridging over courses, so practitioners will understand whether they are eligible to apply for a license. And this will lessen their resistance to the bill because of uncertainty. It is said that after the 36-month transition period, there will not be provisional licenses issued. Now, in order to allow the industry to continue to develop in the interim, we believe there should be a 36-month trainer or training kind of license, so that those who are not exactly qualified but who would like to join the industry can apply for such provisional licenses. And after that, there should be a clause providing for the extension of the provisional license, so PMCs will be able to hire the relevant trained people so the industry can continue to develop. We believe the PMSA will face a lot of administrative work in the initial stage of the licensing system. We're very happy to provide our professional opinion in order to assist the PMSA. We hope the bill will be carried soon so we can enhance the professional standard of the industry. We will do our best to assist the PMSA in its licensing work. Thank you. Next, Mr. Bonnie Chiu. Chairman, I represent the Chartered Institute of Housing Asian Pacific Branch. With regard to the PMP licensing system in the bill, we support it wholeheartedly. We believe the policy can enhance the overall quality of the industry. It can also ensure the PMPs attach importance to their professional integrity. We have 5 particular views. Number 1, criteria for Tier 1 license. We agree that Tier 1 license should cover 3 things: academic qualification, that it should be a holder of a degree of or equivalent professional diploma qualification. In fact, many members of our institute have read a 3-year property management diploma organized by SPACE of Hong Kong U, and that program has been in Hong Kong for 4 years. Number 2, professional qualification. We believe it should be a holder of professional membership granted by recognized professional housing management institutes. And C, relevant working experience. We believe the person should not have less than 5 years relevant working experience in housing management. Number 2, the composition of PMSA and its disciplinary panel. We strongly recommend to increase the proportion of representatives of housing practitioners in the PMSA and the disciplinary panel, and these representatives should take up 50% of the membership, so there will be a clearer insight of the operation of the industry, contributing to the formulation of details of the licensing system. And also, it will assist the disciplinary panel in handling complaints in a fair and proper manner. Number 3, the consultation on property management policy. We suggest that when you draft the subsidiary legislation or the code of conduct for practitioners, you must consult the professional bodies. Number 4, senior practitioners. We believe that in the property management industry there are many senior practitioners who have made huge contribution to the industry, and sometimes they occupy high up positions in PMCs. We believe after the bill comes into operation, there should be a one-off Tier 1 license issue in order to preserve these people and allow them to stay in the trade. Number 5, training. We recommend that the government should put more resources to support local universities which run courses on or degree courses in housing management. And also there should be assistance or subsidies given to the trainees so young people would be happy to join the trade. Thank you, Mr. Gary Young. Thank you, Chairman. I represent the Hong Kong Institute of Surveyors. In principle, we support the bill. But with regard to the criteria for licensing, transitional arrangements, and also composition of the PMSA, we don't see a lot of detailed views, and these are our proposals. With regard to licensing criteria for PMCs, there must be a system which is not lower than the present standards. The HAB and also the Hong Kong HA in the predetermination list, they have got a list of criteria, and I believe the PMSA can make reference to that set of criteria. One of the criteria for licensing PMCs would be on the employment of Tier 1 managers as full-time directors or officers according to the number of properties they manage. And also there must be not fewer than one Tier 1 or Tier 2 PMP looking after one property. And also the licensing criteria should not be lower than the present criteria adopted by the industry. When procurement is done by the departments in the government, it will require that the PMP in a certain housing project must have certain professional qualification. We believe we should follow the present practice of government departments. And then composition of the PMSA. According to Schedule 3, only a quarter of the members would come from the industry. We believe this is grossly inadequate. We believe there should not be fewer than 1/3 of members coming from the professional bodies like the Hong Kong Institute of Surveyors, so that professional judgment can be done. In terms of investigation into complaints and also appeals handling, the composition of the appeal panel, appeal tribunal, etc., not fewer than half of the members should come from the industry, so there will be fair judgment. Number 3, transitional arrangements. Existing PMCs and PMPs should be issued a proper license without the issue of a provisional license if they already comply with the criteria. As for provisional license, we believe they are necessary because they may be very rich in experience, but they do not have the academic or professional qualification, and there should be a one-off issue of provisional licenses. And maybe you should look at the criteria or benchmark of existing professional property management bodies in order to map out your provisional arrangements. This is our view, and we have carried the same views in detail in a submission already given to you. Right, thank you very much. Next, Mr. Chiu Yan Loy. Thank you. I represent the Labour Party.
The Labour Party supports the proposal to regulate the property management profession. Over the years, we have seen in our district, many PMCs who have actually there are many malpractices of these PMCs, and eventually all these boils down to the question of money. The biggest issue is that very often the owners would have arguments with the PMC regarding the remunerations of the PMCs. The remuneration is the major source of income for the property management company. Under this system, the larger the expenditure for the management of the estate, the higher the remuneration for the PMCs. Under this system, there is no incentive for the for them to lower the expenses regarding the management of the housing estate. And we don't have a system for the owners to hold the PMCs in checks. But the owners are only volunteers. They don't have the professional background. When faced with the professionals in the PMCs who resort to different means to spend the money of the owners of the estate, then there's nothing the owners can do. We have seen many scenarios in which the owners in corporations or the owners committees have seen, irregular expenditures on the budget. For example, the cleansing of the external walls, and the PMC would renovate the estate, once every few years, or replace the traditional lamps with LED lamps. And all these projects cost millions of dollars. The small owners simply don't know how to deal with these PMCs. On the other hand, the small owners have one last resort, that is convening an owners meeting in order to agree with the PMCs on matters like the remuneration of the PMCs and which items will not count as part of the PMC's remuneration. But the property management companies have their own professional terms and excuses to refuse the demand by owners, and if the owners want to dismiss the PMC, they will need to convene an owners meeting with more than half of the shares in favor before they can remove the PMC. If the small owners don't have the ability to actually fight against the PMCs and the large consortium behind it, then there's nothing they can do. Thank you. Next, Madam Lee Siu Ying, Miss Edith Lee. Thank you. I hope the deputations present, the electrical members and officials from the Home Affairs Bureau will really have the heart to uphold social justice. We hope that in the management of a housing estate, such social justice can be upheld. I'm a social worker. A few years ago, something happened in the estate I live. There was a DVD exposing the malpractices of the PMC of our estate, so that owners came to learn about the malpractices of the PMC. We found that the property management manager, if he or she did a good job or is willing to manage the estate properly, then he would disappear very soon. And for the other property managers whom we found are problematic, we would be told that he has been, transferred, and the property management company would, and then would saying the thing, and there's nothing we can do about it. So we therefore support that there should be a licensing regime for professional property managers. And if the PMC does anything which damages the interests of the owners, then they should be held liable. For property management PMC managers, even though they have the experience, they may not have the integrity. They have the integrity, may help them actually, obtain a higher remuneration, but we want someone who is experienced and willing to work for us. For the senior management of the PMC, if they don't have the ability to manage the petitioners, and it would also be at the expense of the owners. Regarding the remuneration of the property managers, last month in our estate we have 20% of the owners petitioning the PMC to cut the salary of the property manager, and they promised to give us a reply in 3 weeks. A few days ago we were told that we should first set up our owners incorporation before they would deal with the matter. As a senior staff of the PMC, if he is a licensed person, why is it that in dealing with such matters he would renege on what he has promised us? So where can we take our complaints to? According to our previous experience, when we deal with the problems of the PMCs, very often we have to resort to legal proceedings and have to spend a lot of money. Why, if we want a PMC to do a good job, why is it that they can use the owner's money and actually, take legal action against us? We hope that under the licensing regime we can better manage the PMC. On the for the Property Management Service Authority, we propose that other than professionals from the industry, people who are not in the property management profession will also be able to be appointed to the authority. I think your time is up, Madam Lee. If you have anything further to say, you can make up for that in your written submission. Next, Mr. Leung Lap Sun. Chairman, I represent the concerned group of the Wing-sheung Garden. Our concerned group was set up thanks to Cap 344. There's a lot of grey areas in under Cap 344 at the expense of the small owners. Now that you are now putting forward the property management services bill, and we hope that members of LegCo and the Home Affairs Bureau, when you vet this bill, please actually bear in mind the interests of small owners rather than just focusing on the PMCs and the PMPs. Because I think eventually all regulations aim to serve the owners. Regarding Part 2 of the bill, and in particular Sections 6 and 7, I have the following comment. Section 6 would forbid any person who was not licensed to perform property management services. Section 7(3) bracket 4 allow the owners or organizations or the owners can provide property management service without a license. So is this actually contrary to the spirit behind the bill? On the one hand, you want to regulate the PMCs to enhance service standards. On the other hand, you are creating the precedent allowing owners' organizations to engage in property management services without a license. So can they manage the property themselves, or can they in their own capacity engage another management company, in which case you have a non-professional directing a professional what to do. Housing estate can easily have more than 1,000 flats without an experienced owners incorporation to manage a large residential estate. I really wonder whether they have the ability. Another point is that when the owners corporations, if members of the owners corporation have the powers of a PMC, it can be very dangerous. Take our estate, for example. There was once 5% of the owners asking PMC to provide some documents to us. Fortunately, the PMC was more independent and they were able to provide the document, but the owners incorporation applied pressure on them, and as a result, owners are not given such documents. So I have a suggestion regarding Section 7(3). That is, the bill can apply to housing estates with fewer than 100 flats. For estates with more than 100 flats, they should be managed by professional licensed property managers. And if the owners incorporation or owners organization can become the PMC, this should require the consent of 30% of the owners. Thank you. Next, we have Madam Sandy Fong. The MTRC has already provided a written submission, so members may refer to our submission. So nothing further. Next, Mr. Lam Cheuk Ting. Good morning, Chairman. I represent the Property Owners Anti-Bid Rigging Alliance. Our alliance is very strongly in favor of the proposal to regulate the property management practitioners so that we can, tackle the problem of bid rigging. There are many black sheep in the property management industry. They collude with consultants, engineering firms, and corrupt owners incorporation officials, and even triad members. They work together to monopolize the large-scale renovation projects for housing estates. They're involved in, bid rigging, exaggerating the cost of renovation by 2 or 3 times, and they would control the entire bidding process, thus seriously jeopardizing the interests of the owners. Also, there are many PMCs who would outsource the property management services or contracts to related companies at a high cost without making a declaration to the owners. And as a result, there is serious conflict of interest. Our alliance, therefore, would demand that the future PMSA should have a demerit system to seriously penalize those PMCs which are cheating the owners or are involved in bid rigging. And for those who have seriously breached the rules should be have their license removed. We should also require the PMCs before they invite tender to declare whether they have invited related companies to bid for the tender, including the shareholders and senior management of the PMC, whether or not they have been involved in the tender, so that we can avoid any conflict of interest and protect the interests of owners. Right now, the Building Management Ordinance does not provide any penalties, and there is a serious loophole. Our alliance proposed that we should amend the legislation requiring the PMSA to seriously penalize PMCs which deliberately breach the rules. The administration now proposes that the PMSA should comprise of members of the industry, and we are very concerned that it will be a repeat of what happened with the medical council, namely that members of the profession will condone each other and thus hurting the interests of small owners. We believe that it should be persons with integrity and reputation, and as well as owner representatives should become members of PMSA. Finally, the Secretary for the Home Affairs is present today, and I'd like to reprimand the government for overlooking the problem of bid rigging over the years. Mr. Chung Tak-sing, the Secretary, has expressed his concern, but he has refused to meet with our alliance, and we would like to strongly reprimand the administration for that. Next, Mr. Wing-sheung Kin. Thank you. Good morning. I represent the Democratic Party to make the following submissions. First of all, we agreed that we should regulate property management, the management industry through a licensing regime so that service standard can be improved. In the eyes of the public, the property management profession in Hong Kong, has a problem in that there is a wide variation of professional standards. So in terms of we have problems like bid rigging and so on. We are now on the self-discipline of the professional institutes. Our position is that we should regulate the profession so that we can ensure standard. And our party has the following suggestions regarding the bill. First of all, the government should consider to add a provision that to ensure that the licensed PMCs in future and the PMPs will need to follow the Code of Conduct under Cap 344. And secondly, the government should at this stage immediately regulate the PMCs and the PMP that in the Code of Conduct. I think the public and electrical should be involved in the discussion rather than waiting for the setting up of the PMSA to draft the Code of Conduct. I think we can do that earlier. With the establishment of the authority, we can start to draft the code, but then the discussion can start now. Also, for the tertiary institutions and the human resources training agencies should provide proper vocational training for the practitioners so that within the 3-year transitional period they can migrate to smoothly to the licensing system. And also like to ask whether the government can provide for a structure for the training of the professionals. In the past, we had problems like various problems, including the problem of the tuition fees being too expensive. Things are better for the social workers, but for real estate agents, insurance agents, and traditional Chinese medicine, so on, there have been problems which resulted in the practitioners very difficult to comply with the system. And also the PMSA should be involved in providing support for the frontline practitioners. At the moment, you have 120 people under the Home Affairs Bureau to working at the front line. So in terms of resource allocation, it is not very balanced. There are 120 20% providing frontline support. I hope the Home Affairs Bureau will provide the support in order that we can have if proper regulation. Thank you, Chairman. I'm Man Chiwa, the chairman of the as the owner of a standalone building. I agree that I support the proposed property management regulatory regime.
However, if in the process of regulation you prevent a lot of practitioners from staying in the industry, and as a result there would have to be a higher fee to be paid for property management, then that is not something we want to see. We want to have a suitable number of practitioners who can stay in the industry, so we do not have to see a hike of management fees. I'd like to speak on the bill, and I have 2 points. Clause 7, 3 and 4, it has been mentioned by others. I think this is a gray area. I think it is too lenient. It seems you are encouraging owners' corporations not to hire PMCs. I agree with the previous speaker that we should set some restrictions. I would say if a building has 30 to 40 flats, that should be the threshold. Any buildings that has a bigger number of flats should hire a PMC to do the management, or else there may be problems. We also have a lot of tenement buildings and standalone buildings which have to be managed by owners themselves. As we heard, there was this unique example. However, the PMSA can consider issuing provisional licenses so owners can manage their own properties. But these provisional licenses should be subject to conditions that owners should only manage their own buildings, and if the owners are no longer members of an OC, then the license can be revoked. As for the composition of the PMSA, I agree with the present proposal that half of the people should be lay members, because I don't want to see people in the industry regulating their own kind. Now, the proposed composition is that a quarter of the people would be from the industry. I agree with that. But the industry has said that Tier 1 membership should be increased, and I would say it should be kept at 1/3. And lastly, I like to say that owners have the ultimate responsibility, and they should be the one doing the best management. The PMSA should also help to train our owners so they can monitor the work of the PMCs. And also they would not lodge frivolous and vexatious complaints. Thank you, Mr. Davis Wong. Thank you, Chairman. I represent the Federation of Hong Kong Property Management Industry Limited. We are formed by small and medium-sized independent property management companies. We believe we should follow the guiding principles and policy objectives of the previous consultation paper, and that is there should not be monopoly in the market, and secondly, there should be a grandfathering rule. In order to make sure that existing operators can continue in the trade, we believe that before the bill kicks into action, if there are 5 years experience, then there should be exemption of any examination or academic qualification. Because in 2010, before the consultation paper was issued, some companies had already been in operation. And today they are still in the market, and that goes to show that these companies are operating well. Of course, we should require them to do continuous professional development. And secondly, there should be promotion of healthy development of the market. You must make sure that there will be a critical mass of PMCs and PMPs to serve the community. We agree that young industry practitioners should continue with further studies in order to enhance the overall standard of the trade. We believe there should be a fund for sustainable development of the industry, so you can subsidize further studies by practitioners, and also you can help with the executive expenditure of companies which need to hire more qualified people. Since SMEs in the industry usually manage stand-alone residential buildings, most of the meetings should be held in the evening. We believe the courses, therefore, should not run only for 3-4 years, but 6 years, so that the practitioners can find time to do further studies and get enhanced. Since training will take time, we believe the transitional period should be extended to 6 years, so as to tie in with your policy objective. We must make sure that there would be a better and also more qualified effective PM service. In Hong Kong, there are 16,000 buildings without property management services. Even after the enactment of the bill, these buildings will not benefit from any management improvement. I would say that there should be a fund for buildings to hire PMCs for the first time, so that the OCs will not be managing their own property but become a monitoring agent only. I hope there will be better division of labor in property management, so there will be overall improvement. Thank you. Next, Mr. Andy Chan. Thank you, Chairman, members and officials, and also colleagues in the industry. I am Andy Chan. I represent the Hong Kong Institute of Real Estate Administrators. We were set up in 1985. We are a professional body including the professional people in the industry. We have property management professionals and also surveyors. With regard to this bill and the licensing system proposed, we understand PMPs will be regulated. We have sought the views of our members, and we'd like to present the following views. The bill mentions that there will be a two-tier system to license PMPs. The criteria are about academic qualification, professional qualification, and also work experience. However, we do not see any specific details in the bill, and would like to make the following proposals. In fact, there are many experienced practitioners in the industry. They may not have very high academic qualification or any professional qualification. They have been in the trade for many, many years, and some of them have become officers or even bosses of PMCs. We should recognize their experience. Making reference to the estate agents licensing ordinance, CAP, or actually the regulation, CAP 511A, it is said that in the 7 years before the ordinance came into action, if the experienced estate agents have had 6 years of experience or have read the designated training course, then they would be able to get a estate agent license, and also their license would be renewed. We believe we can make reference to such a mode of operation, and then for experienced practitioners in the trade, we should issue them with Tier 1 license, which will be forever, so we can preserve the experienced people in the industry, so that there will not be such a big impact. And also, as for the criteria on academic qualification and professional qualification, I think it is an incentive for practitioners to continue their professional development. To do this, there should be courses operated, and there should be subsidies provided by the government to practitioners and the tertiary institutes that run the courses. And also, when you look at the licensing fee, you must look at the factor of affordability. that it should not be higher than $900 per year. As for inexperienced practitioners who have worked for only 2 to 3 years and who are not involved in supervisory work, we believe we should exempt them from getting a personal license. Okay, your time is up. Thank you.
團體代表同埋個別人士呢，就
I think that's it for deputations and individuals. Next, we will ask the administration to give a response to the views of the deputations and individuals. Can we have an initial response from the administration first? Now, because of time constraint, I would say that, Director, you can first speak on the policy. After the meeting, you can give a consolidated written reply to the views expressed. I'm also aware that some speakers have spoken specifically on certain clauses in the bill. I think the administration can consider replying to those in writing, because when we come to clause-by-clause examination, I'm sure members would like to refer to those views, and that would facilitate our discussion. After the administration has spoken, I will open the floor to members for questions and answers. And members can then ask questions of the deputations or the administration. Mrs. Tan. Thank you, Chairman. I think I will spend a few minutes in giving my response. First of all, I'd like to thank the deputations and individuals for the valuable views on the bill. I have heard that all speakers are in support of the introduction of a licensing system on the property management industry. I understand some points have been made by a majority of speakers. Many speakers talked about the quality of the present service. They said the government should regulate the industry effectively in order to protect owners. This is exactly the objective of the bill. We'd like to introduce a licensing system so PMCs and PMPs will be subject to a benchmark so that they can enhance the quality of their service. Licensed PMCs and PMPs can be penalized by the PMSA if they should break any rules and regulations. The details will be included in the primary legislation, subsidiary legislation, and also the code of conduct to be drawn up. It is said that owners will have to rely on PMCs to assist them and to give them professional advice, so owners can comply with laws, including the buildings ordinance and also the lifts and escalators ordinance. They need professional advice on such. This will be covered in subsidiary legislation or the code of conduct. We will give details on the responsibilities of PMCs and PMPs in order to protect the interest of owners. I have also heard that owners and PMCs may be standing on opposite sides, and that is quite natural. And also there may be conflicts between the owners committee and the PMCs. I can say here that I have heard some specific requests. Just now it was said that whether disciplinary action taken could be published on the internet. Well, the record of disciplinary action can be inspected by the public. It was asked whether the PMCs should only serve the OC or all owners. Again, this will be detailed in the law later.
Also, some of you also ask whether or not a PMC, whether information regarding the PMC and its related companies will be hidden. Section 16 of the bill already requires the PMC to provide information relating to any potential conflict of interest. It was also suggested that sometimes the owners may make unreasonable demands of the PMCs and the PMPs, and these demands may be illegal. In this regard, the owners and the owners in corporation have the duty to comply with the requirements of the law. Just because the OC has appointed the PMC, it doesn't mean that the responsibility stops there. The owners in corporation and the PMC should jointly comply with the law. We understand that the arguments between owners and the PMC very often involve the finance, the question of finance. In the subsidiary legislation and the code of conduct that we will draft in the future will also have clear requirements regarding financial management. For example, the PMC will be required to submit within a specified time period a budget for the estate that they manage, and that there should be an annual financial report. And when the old PMC hand over to a new PMC, during the transition we will require that the transition should be smooth, and that the former PMC must hand over all the relevant information to the new PMC so that we can ensure the continued smooth management of the estate. Several deputations made reference to the PMSA, the composition of PMSA and the appeals tribunal. In Schedule 3 of the bill, Section 2 of the schedule, it is stipulated that members of the PMSC will be appointed by the Chief Executive. The PMSA will comprise a chairman, a vice chairman, and not more than 18 members. As to how these people are to be selected, 1/4 of the members will come from those who are in the property management profession. Another quarter will be lay members, but who have experience in respect of administration and consumer protection and so on. The third category will be the lay members. The second category will be those who may have some experience in property management. We want to we don't want the PMSA to give the impression that it's allowing the members of the profession to regulate their own peers. So the proposed composition of PMSA is aimed at providing the proper balance. Amongst the members of the PMSA, we hope we can reflect or represent the interests of the different stakeholders. Regarding how we will deal with the appeals, of course, for each appeal, there will be an appeals panel comprising a chairman and 2 members. The chairman and the 2 members will be appointed from a pool of members to hear the appeal. The appeals panel comprises 12 members, including professionals who will have the expertise. It will also have lay members who will be able to deal with each appeal in a fair and just manner. Some representatives of professional bodies have expressed concern about the transitional arrangement. Our present proposal is that there will be a 3-year transitional period. For those who are already very experienced in industry, but they may not have the proper academic qualification that meet with the requirements of the law. And for these practitioners, we are now proposing to set up a temporary licensing system. Within those 3 years, they can apply for a temporary license so that they can continue to work in the profession. However, we also have some requirements for them, and such requirements are also reasonable requirements. After they've obtained a temporary license, we'll allow them 3 years, and during which time they can attend supplementary courses or professional courses. And after they have completed such courses, they can apply for a proper license from the PMSA. I will not rule out the possibility that the PMSA may not require them to actually attend lectures because we understand that these practitioners are already very experienced in the field. Perhaps through the submission of theses and explaining how they deal with particular scenarios, the PMSA will be able to assess whether or not they have the professional expertise and issue them with a license accordingly. Someone also suggested that we should ensure there will be sufficient courses and that the quality of the courses are good and that the fees are affordable. The PMSA will work with the tertiary institutions and the profession to ensure that that there will be a satisfactory solution to those concerns. Many tertiary institutions are already providing property management courses. The quality, there's already have some quality assurance there. We are confident that such quality courses will be provided to those in the profession, and the fees will also, should also be reasonable and affordable for the practitioners in the field. Several deputations expressed concern about the licensing criteria and asked whether or not it would be too stringent. We follow two guiding principles here. First of all, we want to ensure that the licensed PMCs and the PMPs will have the required standard. Another principle we abide by is that we do not want to adversely affect those who are already in the profession, and we don't want to adversely affect the survival of the PMCs, which are SMEs. In the subsidiary legislation and other supplementary requirements will be attached to the license, and all these criteria will be based on those two guiding principles. Other than the licensing criteria, the PMSA will also have other measures in place to ensure quality. That is, for the PMCs which are licensed, information pertaining to such PMCs will be put on to the website, so that for any building, any housing estate which wants to engage a PMC, they will have more objective information to help them make the decision. And if a licensed person has been subject to disciplinary sanctions, again, such records will be accessible for the public. One individual expressed his concern about the question of bid rigging. Perhaps the administration is very concerned about crimes relating to building renovation. Several departments, including the ICAC, the Police Department, and the Home Affairs Department, and also the Urban Renewal Authority and the Housing Society, have all along been working together to tackle this problem. Well, there have been active investigation and law enforcement. We also conduct public education to help owners and owners in corporation to streamline the procedures And for buildings without any owners corporation, we also provide them with support so that we can stop these malpractices. Another important point is that the competition bill has now been enacted and is in 2012. According to the competition ordinance, if any business entity has has any bid rigging agreements, it will be in breach of the competition ordinance. The judiciary and the relevant authorities are now making preparation to fully implement the competition ordinance. After all the preparatory work have been completed, then the bill will come into force. And finally, this morning, several individuals mentioned that the current buildings ordinance, GAP 344, has many grey areas which need to be improved upon. We understand that, and that's why we've set up a review committee to help us look at each and every clause of the ordinance. And for frequently encountered problems, the review committee has also made some recommendations. The administration is now following up on the recommendations of that review committee. We hope that in the latter half of this year, we can put forward a proposal for public consultation. Thank you, Mrs. Tan. Next, it's now time for members to ask questions. 5 members have indicated that they would like to speak. 6 now. And I'll read out the names. Mr. Wong Kok Heng, Yik Chi Ming, Claudia Mo, Chen Kim Bo, Chiang Kwok Chu, and the Vice Chairman, Mr. Wu Chi Wai. May I suggest 4 minutes for each member? That's questions and answers included. One deputation, Mr. Young Ho Chun, has just arrived. I don't know whether or not members would object to Mr. Young, first of all, make his submission. I understand that Mr. Chi Ming would like to leave earlier. So, Mr. Wong Kok Heng, would you like to swap your place with him? Okay, thank you. Mr. Young Ho Chin, I'd like to remind Mr. Young that what you're going to say will not be covered by the LegCo's Powers and Privilege Ordinance. And the same applies to your written submission. Mr. Young, thank you. I'm Yang Ho-Chin from the Liberal Party. We basically support the proposed licensing mechanism, but we hope the government will do better in terms of the details. For example, for those PMPs who are already in the industry, they may not have a lot of academic qualification. The 3-year transitional period may not be enough. So that would actually have an adverse impact on their career development. To some extent, we hope that the government can reasonably lower the requirements for these professionals. I heard the administration already responded to this point earlier. For the PMPs who are already reaching the 50s or approaching 60, if all of a sudden they are required to attend further training, not to mention whether or not the training will actually be effective or work. And by the time they've completed the training, they will already have reached retirement age. So we hope that the government can come up with some relief measures to help to cater to those two scenarios. Thank you. So it's now question time for members. We'll start with Mr. Yik. Thank you. First of all, I'd like to thank the deputations for coming here to give us your views. One point I'd like to follow up on is the question about the veterans in the profession who have many years of experience. Mr. Chen Chi-keung also said that for the real estate agents, there was also a one-off, transitional arrangement. Many years ago, when the electricians needed to be licensed, the employers, after recognizing qualification, would mean that the practitioners will automatically be given a license. Although we understand that they will be still able to practice during the 3-year transition period, and meanwhile they'll be required to attend courses. And we asked whether or not they were simply required to attend the course, and then you told us that they would need to also take an examination. As one deputation said, they already very advanced in age, they have a lot of experience, and you still require them to sit for an examination. It will have an adverse impact on the careers and feelings. So I'd like to know whether or not you would follow some previous practice and waive such requirements for them.
Just now, I heard different views. Some people say that PMCs are not doing well. Others complain against OIs or OCs. After the licensing system is in place, you can revoke the license, and it is a very heavy penalty, and PMCs would definitely become more professional. But sometimes the problem with the IO, will the law also regulate IOs? If not, will there be unfairness? And also some speakers said that there could be vexatious complaints. In fact, I have seen some in my own housing estate or development. Number 3, some speakers mentioned that IOs complain PMCs because PMCs are not professional, or that their staff have integrity problems. I'd like to know how you would tackle this in the law. Who will take the questions? Director. First, is it that there should be an examination after taking courses? I said if they would like to submit articles or theses instead of reading courses, then they would be examined, I said. But in fact, both are the same. If they read courses, they would just have to comply with the number of hours required without sitting a final examination. And sometimes the instructors will give some so-called homework for them to do, and if they get a pass for those, then it will be okay. We understand there are very experienced practitioners who are also busy because they hold a high position, and they may not have time for that many hours of training. So we provide an alternative route, so they can submit a thesis. Say somebody has tackled a very unique situation which may serve as a kind of pioneer case study, then yes, the thesis can be submitted for vetting, and that is for practitioners to choose. Just now it was asked, what if OCs or IOs do not do a good job? Will they be subject to penalty? In fact, OCs have to comply with legal requirements as well. We do not intend to penalize OCs because OC members work as volunteers to serve their own building. We want to encourage this, and our attitude is to help them. The HAD provides courses and conducts meeting with them so we can assist them in their role in managing the building. Thank you, Mr. Wong Kwok Heng. Thank you, Chair. I'd like to thank the deputations and individuals for coming. Actually, in the last legislative session, I was the first one to raise such an issue. Why? Because I have 24 years of experience in working with OCs and tenants associations, and I can very well understand that owners' interests are not adequately protected by Cap 344, because Cap 344 has a lot of loopholes and gray areas. Small owners are not exactly protected by the law. Certainly, there are many problems between PMCs and small owners, and we need to find a balance and mutual monitoring. So property management can become more professional and can develop in a healthy manner. I think that is important. I can see that deputations today are very supportive of the bill. I'd like to thank you, and I'm happy to see that. Undoubtedly, after the bill becomes law, there will still be room for improvement, but that will come later. We will have to take stock of the experience of implementing the law. But at this stage, I'd like to ask a question. Just now, I'm aware that representatives of the industry have spoken on the composition of the PMSA. I have heard first that you would like half of the members, or not fewer than half of the members, coming from the trade. Some other people say 1/3. My own view is that I support the administration's proposal that only a quarter of the people should come from the trade. Why do I side with the government on this issue of composition of PMSA? I am of the view that this is going to be a very important body. The PMSA has to make sure that it can protect the interests of small owners, and also to balance it against the professional bodies. We don't want to give the public the impression that the PMSA is dominated by the industry. As a matter of fact, the government will balance different factors when making appointments. I'm sure it can win your trust. As we said, the PMSA will have 3 sources of membership. As a matter of fact, many buildings that do not have OCs, because invariably the property developer monopolizes the market. I can give you an example. The MTR properties, you can never set up any OCs under the present law. Very often, small owners cannot set up OCs because the property is dominated by the developer. This is a loophole in Cap 344. I believe the government's proposal about the PMSA is really for protecting small owners. Can I ask for some time for the administration to respond? Maybe later, all right? I believe there will still be time. I will allow other members to have a go first. Next, Ms. Claudia Mo. Thank you, Chairman. Small owners and PMCs are always on opposite sides. I think that is a fact. And we have heard that small owners cannot speak out. And sometimes the professional bodies are saying that owners can sometimes be unreasonable and they make unfounded or groundless complaints. I really agree with Mr. Leung from Grenville Garden that the bill should be premised on the interests of small owners. Now, just now we talked about a balance, but we are not talking about the average consumer. Owners, especially the small ones, have put in their life savings in a flat, and if there is major maintenance, etc., and if there is a hefty fee required, then without an OC or a good PMC, these small owners would really be disadvantaged. I, of course, understand the worries of a layman ruling over professionals, but then we also have to be careful about collusion. And you must regard, first and foremost, the interests of small owners. Talking about conflicts of interest, I was very happy to hear from the director that we understand very often tenders are rigged, and this is very worrying to small owners because people can gang together and collude. But you said we have the ICAC Housing Department, we will soon have the competition ordinance as well. But then exactly because we have so many channels for complaint, people don't know where to go. Can you consider having the PMSA playing the leading role in future? And owners should take everything to the PMSA. And the PMSA will then refer the cases to the relevant departments. I have handled cases where you take the complaint to the ICAC and they will always say you do not have enough evidence. And that was so disturbing to small owners. And so perhaps I'd like you to do some referral first. This is the first point. Secondly, conflict of interest. I'm talking about the manager's fee. I think this is the biggest conflict of interest. You did not mention that in your reply just now. Can we map out the details in the bill? And as for licensing, as the chairman said, when we come to clause-by-clause examination, whether there will be automatic, professional or trainee licenses, we can wait. But those are the two questions on conflicts of interest. Mrs. Tan, I have heard that you'd like to give emphasis or place emphasis on the interests of small owners. Indeed, we have shown or paid attention to that. However, if we make it too strict, if the professional industry will shrink as a result, that will be unwise, and that is why we like to strike a balance with the objective of having good management for Hong Kong buildings. We talked about tender rigging. You say there are too many departments looking after this, whether we can have a one-stop service. I believe the relevant departments should take up the matter together to see how a better service can be provided. I believe it is up to the relevant departments. And then the manager fee. I think this will be included in the DMCs. And we can review the guidelines, the relevant guidelines, and that will not be included in the bill. Okay, next one, Chen Kin-po. First, I'd like to thank deputations and individuals for coming. I am the chairman of an owners committee including 3,000 flats. So I have a lot of understanding about these matters. I know the HAB would like to encourage owners to manage their own building if they are stand-alone buildings. But as Mr. Leung Lepson of Grandview Garden pointed out just now, that you allow people who have no property management experience, especially owners, to manage their own building. I think that is a big problem. I agree with Mr. Leung's proposal that this should only apply to buildings with fewer than 100 flats. Just now, Mr. Man Chi-wah also said that this should be lowered to just 30 to 40 flats. However, the common thread is that we might be able to allow non-professional management of buildings only with fewer units. However, if the estate has more than 1,000 units, I believe it is a loophole for you to allow them to manage their own buildings without engaging professional service. I hope you will face up to this issue. Secondly, I like to thank Mr. Fong Kwok Hong. He said something I have heard for the first time, and that is excessive interference by owners. I think this will happen to OCs, which represents owners in monitoring and supervise the PMCs.
We find many unscrupulous people because they have too much powers. So without a system to regulate these people, you indeed will have this problem. Cap 344, as we all know, and the director also told us that there are grey areas. I would say that there are far too many problems in respect of Cap 344. For example, your guidelines related to proxies and so on. I think the complaints can only be taken to the Land Tribunal, but if the owners have to take the case to the Land Tribunal, it's really a very serious matter taking a long time. We already understand that there are a lot of problems with Cap 344, and I've already discussed with the director as to how we can improve on that piece of legislation, especially it should provide for, penalties. So that properties can be managed in a better way. I would like to also ask Ms. Wong Kok Hong to tell us whether or not there is indeed this problem of owners involving too much or excessively in the management of their own properties. Well, in my experience, I've come across many owners in corporation. Indeed, some owners in corporation may, because of personal interest, involve too much in the management of the properties. According to my observation, although there is no concrete evidence, there are some owners in corporation which are involved excessively in the management of the work of the PMC. The PMCs are regulated by professional institutions and so on, but the owners are not regulated in any way at all. According to observation, indeed, we have this problem, especially for young people joining our profession. Many of them are unwilling to join our profession because if they, do the work fairly, the members of the OC may not be happy. They may scold you or even dismiss you. So I hope that in the bill, the government would consider, clarifying the criteria for exempting the owners, and that exemption should only be given to developments with a very small number of units. Thank you. Next, Mr. Cheung Kwok Chu. Thank you. Again, I'd like to thank the deputations and individuals for coming here to give us the views. I have not read the bill in detail, but as I heard the deputations, I understand that there are several difficulties. We're now talking about the licensing of PMCs, the licensing of PMPs. But for standalone buildings, would they be able to engage such professionals? There are many PMCs which simply don't want to manage standalone buildings. So how can, with the enactment of this bill, how are we going to deal with the problems relating to standalone buildings? Perhaps the officials could respond to this. Also, Mr. Chen Kin-po refer to Cap 344, and there are certainly conflicts of that bill ordinance with the bill. Could the administration tell us where are the areas where there are conflicts so that we can first, enact this bill and then amend Cap 344 afterwards? Because all these problems are not resolved, then people will be able to make use of these loopholes. Even if you tell us now that you cannot immediately resolve this problem, but you're willing to do it at a later stage, at least that is a good thing. Otherwise, if you pretend that there are no problems, then eventually it will be a very serious problem. So I would like to also ask the deputation to tell us more about the conflicts between 344 and this bill. Thirdly, there are professional institutes with their own views, so it would be, you say that it would be best that, your members don't need to do anything and can automatically be licensed. So could the government tell us how they will talk to the professional bodies so that we can really satisfy the requirements of the bill while at the same time, take care of the interest of the public and work out a solution with them. Would you like the administration to first respond? I think both sides can ask my question. Why don't we ask the deputation start first, whether or not, to tell us whether or not there are any conflicts? Mr. Lam, thank you. Please switch on your microphone. Thank you, Mr. Cheung. CAP 344 has several serious problems. First of all, that ordinance does not provide for any penalties. The members of OCs can then deliberately breach that ordinance and there are no penalties. CAP 344 also does not provide for a statutory organization to enforce the ordinance. In theory, the Home Affairs Department is responsible for the policy side, but it doesn't have any enforcement powers. As a result, this is an ordinance which is not really enforced at all. Furthermore, there are many loopholes. For example, the Alliance Against Bid Rigging. We found that in many housing estates, there are chairmen of owners in corporation. In order to avoid the responsibility to convene owners' meeting, would resign and still retain the status as members of the owners incorporation, while at the same time not electing a new chairman. The law says that only the chairman can convene a meeting. As a result, for the entire housing estate, all the controversial issues will not be resolved because the owners' meeting cannot be convened. We would ask the Home Affairs Department to amend the ordinance to plug that loophole. But so far, the department has not yet taken any action at all. Mr. Chung Tak-shing, the secretary, had expressed his concern about the anti-bidding bid rigging alliance, but so far he has refused to meet in person with our alliance, and I'd like to strongly condemn the Bureau and the department. Thank you, Mr. Lam. Next, Mr. Wuchiwai. Thank you. I also like to thank all the deputations for their attendance today. I'm sure all the deputations would like to see this bill enacted. But I've also noticed that I would also like to listen to their comments regarding certain parts of the bill. In Section 4, the bill provides said there will be a code of conduct, but we're not given any details. At the last meeting, I pointed out that as a professional property management practitioner, he or she would have to abide by CAP 344, and secondly, the stipulations in DMC, and also the best practices. For example, whether we're talking about fire safety or procurement. We would very much like to put all these in the principal legislation, so that after the PMSA is set up, we would and wait for the PMSA to draft the code of conduct. Some deputations pointed out that some owners may intervene too much with the works of the PMC. One of the reasons for that is that we do not have a clear delineation about those three legislation, and because if it's a question whether or not it will affect your being granted a license, then then you can reflect to the owners that you may not get a license. So you have to tell us whether or not the proposal will actually help you with the work or so. Secondly, Mr. Lam described a scenario where the chairman of the owners incorporation would resign, and the chairman and the government refusing to amend the legislation, and the director said that those involved in property manager the owners are conscientious people to serve on a voluntary basis. But according to Mr. Lam, obviously the chairman he described doesn't have the best of intentions. So do you have to wait until Cap 344 is amended before you would do anything, or would you tackle the problem? For example, a scenario where the chairman resigns and as a result the owners meeting cannot be convened. So can the Home Affairs Department issue some guidelines so that if the members of the owners incorporation does not abide by the rules, this could be evidence which result in the losing in any legal proceedings which may follow. So now, Dr. Chen. Thank you. I agree with Mr. Wu Chi-Wai's observation. He's talked about the three aspects. We have more than 100 pieces of legislation regarding property management. For example, the fire safety regulations, the EMST regulations, and regulations relating to food hygiene. There are more than 100. So far, as far as the enforcement of the law is concerned, one can say that a professional manager, I think he is 10% a lawyer. He had to, for example, take action against unauthorized works pursuant to the DMC. So whether or not you put it into the existing, the present bill, for not only do we need to abide by this what is in this bill, but other legislation as well. So regarding professional qualification, we support the two-tier system. For Tier 1, we believe that the requirement would be higher regarding professional expertise. That is, the person holding Tier 1 license must have a degree holder or attended the professional qualifications. I agree with your observation, but I don't think we should. Well, 344 is one. The PMCs and PMP will need to abide by 344, but that's not the only legislation they have to comply with. All right. Do we have any members for the first round? If not, then so I can now allow members to go for a second round of questions. Do we have any members who would like to ask questions for the second round? Mr. Wu Chi-Wai. Mr. Wong Kok Heng also indicated earlier that he would like to go for a second round, but he's not in the chamber at the moment. So we say 3 minutes for the second round. And if there are no further questions for the second round, then I will wrap up our discussion. Mr. Wu Chi-Wai, 3 minutes. Question and answer included. Actually, I would like to, give time for the profession to respond. I understand that you have to comply with more than 100 legislation. So, will the proposals in this bill make your work more complicated? That's my question. Mr. Lam, please try to be as brief as you can. Thank you. We know that the chairman of some owners corporations are like local warlords, and the PMC would allow them to do certain things which are in breach of 344. If we set up the PMSA and we make it mandatory for those in the property management profession to abide by the provisions of 344, that can really help reduce or minimize the disputes between owners and the PMCs. See, Chi Ming? Please switch on your microphone. I agree with Mr. Johnny Chan. Our professional institute has our own code of practice. As members, we have to abide by the code. 344 is, of course, an important piece of legislation for the property management industry. It regulates owners and also the PMCs. So I don't think it's necessary to put those two legislation in the bill, because those legislation has to be complied with. So I agree with Mr. Johnny Wong. Madam Edith Lee. I'd like to respond to what the director said earlier regarding the manager's fees. Claudia Mo also alluded to this, and she said that it is provided for in the DMC. But the DMC is dictated by the property developer, and owners don't have any say. Every month we have to pay the PMC on a pro rata basis. So we cannot, resolve the problem of, excessive managers' fees. So is there any solution to this problem? The owners incorporation cannot deal with the problem, and so how can we deal with that problem?
Mr. Tam Kwok Wing. Thank you, Chair. Mr. Wu asked whether we should include this in the Property Management Services Bill. I agree with Johnny and Mr. Ip. I represent a company. We need to submit to many laws. I think whether or not these laws are all included in the bill, PMCs and PMPs would have to abide by them anyway. So it's not necessary because we are already doing it. Let me also give some time to Ms. Yong. I will give you 1 minute. Thank you, Chairman. The industry has said a lot of things about supervision, and they would like to have a bigger membership in the PMSA. But I believe in society it is more a case of owners' interests being trampled upon. And we have said that Cap 344 cannot protect the interests of small owners because the law enforcer is actually the director of HAB. That's written into Cap 344, but then she has no enforcement powers. And so Cap 344 is a toothless tiger. And very often, the OC will override other owners. And very often, we have subsidiaries working under parent PMCs, and they try to trample upon the interests of small owners. That is why in my paper, I'd like to mention a particular example. Even OCs cannot dismiss the staff of large PMCs. And therefore, very often, only the large developers or owners are protected. Right, thank you so much, deputations and individuals, for coming to the meeting, and thank you very much for your valuable views. I also thank the administration for coming. I would propose that we can take a break of 5 minutes, and then we can continue our meeting. Thank you.
各位
Members, we can continue with the second part of the meeting. Item 2, we have a meeting with the administration. In our meeting on the 11th of June, members asked the administration for certain information, including the number and qualification of practitioners. The administration has already given a response and the paper has been issued to members. Now let me ask the director of HA, Mrs. Tan, to walk us through that response paper. Yes, Chairman. Existing property management practitioners. As there is currently no mandatory registration system for PMPs, we are unable to provide an accurate estimation of the number of PMPs. However, according to a survey conducted by the Hong Kong Institute of Housing last year, it was estimated that with reference to a few parameters, their own members, including the current number of members, and those who have the relevant professional qualification. I'm talking about diplomas, certificates, or degrees, or even postgraduate degrees. And so they can estimate for us the number of PMPs who will be able to meet the requirements for Tier 1 and Tier 2 in future. As for the number of practitioners required by the market, we look at a few factors. There will be how many buildings that will be built, and also the consumers' demand for professional PM services, and also how many existing practitioners will leave the industry and retire, meaning wastage. All these factors will have a bearing on the number of practitioners, so it is a little difficult to quantify the future requirement. But as a rough estimate, they have made use of the 10-year housing development target, and it is said that there would be 47,000 to 50,000 units built every year.
And they made the assumption that for each Tier 1 PMP, we need to manage 2,000 flats. In order to have effective management, we will need a 1:5 ratio. That is, the property manager would need to be assisted by 5 officers. So with all these projections, they've come up with a figure that every year we will need 150 additional PMPs, of which 25 will be managers and 125 officers. Thank you. Thank you, Director. It's now question time for members. We have 3 members who've indicated that they would like to ask questions. Mr. Wong Kok Heng, Wu Chi Wai, and Mr. Cheung Kok Chi, our Deputy Chairman. So 5 minutes each. Mr. Wong Kok Heng. First of all, I'd like to follow up on a question I raised in the first round, that is about the composition of the PMSA. Could the Director tell us the principle which the government will follow in making appointments to the PMSA? Although I support the proposal that a quarter of the members would come from the property management profession. We've heard different views from the deputations. One asked for 1/3. One would say no less than 50%. So that's my first question. Secondly, for the 2-tier licenses, we're talking basically the property managers and the supervisors. Can we have a more precise definition? Namely, the titles are sometimes called managers, sometimes officers, sometimes senior officers. Without the system in the past, there were different titles being used. Different PMCs will decide on the titles themselves. There is no standard criteria. We're going to have a formal licensing system that we need to have clear definitions. So shouldn't the administration also provide a clearer definition? So 2 questions. Mrs. Tan. First of all, for the composition of the PMSA, 1/4 of the members will come from the profession. We expect that the relevant professional bodies such as the Hong Kong Institute of Housing Managers, the Housing Societies Registration Authority, and the the Asia Pacific chapter of the Chartered Institute of Housing Managers and the Chartered Institute of Surveyors. Members of such institutes will be considered for appointment. Another 1/4 will be those who are not from the profession but have the relevant expertise. What we have in mind will be the lawyers, engineers, architects, or even those who serve in the Consumer Council. So these are the potential candidates to be appointed to the PMSA, namely people who have the relevant expertise regarding property management. There will be 9 lay members, and we're talking about people who want to serve the community while at the same time they are familiar with the operations of owners and corporations and PMCs. We hope this is the composition that we propose for the PMSA. Your second question is, how do we differentiate between the different titles for the petitioners? And in future, how do we have a clear definition? I think the details will be provided for in the subsidiary legislation and the code of conduct. Our thoughts at the moment is that we will look at the number of units which are managed by the PMP and the size of those units. If the scope is wide, obviously if he is in charge of a larger number of units, he would be Tier 1, and if the PMP manages a smaller number of units, then the PMP may not need to require Tier 1 qualification. So will the criteria be decided by the PMSA, or are you going to do it through the subsidiary legislation? That's what we need to consider at the next stage. We will talk to the relevant professionals and then come to a final decision. Since the definition of supervisory and managerial staff, I hope you can come up with a consultation paper earlier so that you can listen to the views of the profession so that we can avoid any disputes. In the past, we didn't have a system, and there were different titles were being used. So, for example, what is the meaning of large and small PMCs? There are different practices. I hope you can give us a consultation paper so that we can consult the public. We attach great importance to the views of electrical members and the stakeholders. Certainly there will be consultation so that we can listen to your views. Mr. Wuchiwai. Thank you. My first question is about the qualifications of the PMPs. I note that the bill does not say whether or not a PMP can be registered through many companies. That is, his name could be, in several companies. As a result, the real number of professionals in a particular PMC is not sufficient for it to perform its duties effectively. But the law doesn't provide for such restrictions. So please clarify that point. And secondly, follow up on the earlier discussion. Some of the deputations suggested that the exemption provisions has no limit. So long as the owners don't engage a PMC, then the owners can manage their own building. Has the government considered that for such exemption systems, you should lay down some restrictions. For example, the number of flats shouldn't exceed a certain threshold. Otherwise, the owners must engage a PMC. Because we're inclined that it would not be easy for the owners to manage, a property with a large number of flats. Assuming that you have a development or a building, the buildings without PMCs are basically located in the older districts with tenement buildings, and we have 2 flats per floor and 12 flats for the whole building. Has the department or the bureau consider, making it a mandatory requirement so that the exemption will not become a loophole? And thirdly, Section 4 about the Code of Conduct. You are proposing to provide the details after the PMSA has been set up. But why can't you, for the important pieces of legislation like 344, the DMCs, and the Professional Code of Conduct, why won't you make them part of the principal legislation, plus what the PMSA will provide, and also the Code of Conduct to be provided for by the PMSA, so that the bill will become clearer, and that when we discuss the subsidiary legislation in future, there would be disagreement, and then you will not put them into the subsidiary legislation. So what I'm saying is that for the important subsidiary legislation, such as CAP 344, the DMCs, and the Code of Conduct, which has already been issued by the government, should be included in the principal legislation. Finally, some deputations said that some owners in corporation may, through the resignation of the chairman, evade the person will evade his responsibility as chairman of the OC, and therefore they can bypass CAP 344. Will the department, by way of a code in the short term, come up with guidelines so that those owners of corporation will not dare to deliberately bypass the requirements of CAP 344? Mrs. Tan, several questions. First of all, Mr. Wu asked whether a licensed person can serve a large number of PMCs. We have some preliminary proposal. Now, for the directors of the PMC, we would require the PMC should at least have a director who is a licensed person, be it Tier 1 or Tier 2. But for the time being, we will not stipulate whether or not the director will serve 1 PMC, 2 or 3 PMCs. Instead, we will have a restriction regarding the number of people who will actually do the management work. For each licensed PMC, we propose that there should be at least 3 licensed PMPs. Of the 3, 1 should be a Tier 1 PMP. For someone with a Tier 1 PMP license, can he therefore claim to be employed by many PMCs? We would stipulate that a Tier 1 PMP will not be able to serve more than 3 property management companies. And secondly, regarding for buildings which are self-managed by the owners, and whether or not we would, in order to improve on the management standard, especially for the buildings in old districts which are not subject to any management at all, we believe that in future If the service standard of the property management profession is good, the price is affordable, it would encourage more owners to make use of the service. But for the time being, we will not make it mandatory for the owners to engage these PMCs. The owners of these buildings may want to cut costs and as a result manage their own buildings. If we immediately make it a requirement that all owners must engage PMCs, then it would be a financial burden for such owners. We therefore believe that we need to think carefully and consider the situation carefully. Deputy Chairman, perhaps you can follow up in the second round to be fair to the other members. Mr. Cheung Kwok Chu, you're next. Thank you. I also like to follow up on Mr. Wu Chi-wai's question. I'm also concerned about buildings which are exempted, namely buildings with a very small number of flats. According to your estimate, what is the number of buildings which will be exempted? I understand that housing estates must comply with the requirements of the bill. So could you give us the information? Secondly, after you've given the exemption, how are you going to deal with the problems relating to operations of these buildings? Because you don't have the bill doesn't regulate these buildings. Will you provide for guidelines for them to follow? Thirdly, the deputations mentioned CAP 344 and how it interfaces with this bill and whether there are any conflicts. Could the government give us some examples? If you can't do that today, at least, well, you may not be able to give an answer now. Perhaps at a later stage, you can give us a paper about problems related to CAP 344 and where in this bill we can resolve those discrepancies, and if not, how is the government going to deal with the conflict of discrepancies? Next, the director might not have time to answer our question. The different professional institutes would like you to follow their system. So will you sit down with all the professional institutions so that you can arrive at a consensus instead of otherwise people will say that you have not respected the views. And finally, the director also alluded to this earlier, that is for the Tier 1 PMP, they should not be allowed to serve more than 3 PMCs. And then the question is why shouldn't it be just 2 or 1 property management companies? First of all, how many buildings will be exempted? We have about 40,000 private buildings in Hong Kong, 1/5 of which are self-managed, namely about 8,000 buildings, and they are managed by the OCs or the owners themselves, and they're exempted. Regarding the interface between CAP 344 and the bill, the purpose of the bill and the ordinance are very clear, covering different areas.
It's not easy to decide how they should interface with each other. No matter what, PMCs have the responsibility to assist owners to comply with 344 and other matters with regard to building safety and hygiene. Owners themselves have the responsibility to comply with the law. In Hong Kong, no one should break the law. That's the general principle. So it doesn't mean that we should try to interface between the two ordinances. But we have already done a review on CAP 344. We have got a review committee set up. It has submitted an interim report and also a final report. Within government now, we are following up on the proposals. We expect that in the latter half of the year, we will be able to come up with a consultation paper on our initial views. And feasible modes on which we have not arrived at a final decision. And after consulting the public, we can propose a bill to the Legislative Council. I can also take up another point. It was said that in this bill, we should write in Cap 344 and other ordinances for the compliance of PMCs. Later on, our legal advisor can say something. But then, we may not be able to be exhaustive with all the rules and regulations to be complied with. So, it is not our normal practice. And of course, I stand to be corrected by our DOJ colleague. So it's not a common practice for us to write in the ordinances that have to be complied with as well. Well, I also like to ask a question, but first of all, I will give the floor to the DOJ to see whether they would like to say anything. Chairman, if we should mention certain ordinances in the Code of Conduct, it is possible that we may leave out some ordinances, so there will be the risk of uncertainty. If we'd like to include certain rules and regulations in the bill, now how should we do it? And we need to give this detailed consideration. So first of all, you need to know and satisfy yourself what you want to put in first. Okay, it's my turn now. Just now, members talked about exemption. We all like to enhance the quality of PM, and if there is grandfathering, how can we ensure then the quality will still go up? You talked about 8,000 buildings without PM service. This is the first point. Second point, Tier 1 and Tier 2. Certainly, first of all, we have to look around the market to see whether we have enough supply of such professionals. You talked about managers being given a Tier 1 license, but the manager can work in a few companies at the same time. He may not just work full-time in one company. I hope you will look into this. How many qualified practitioners do you require in one PMC? That has direct impact on whether there is enough supply of professionals in the market. And as we were saying, some buildings have a small number of units, and so they might require a smaller PMC. But if a PMC is big in establishment, it may need to have a bigger contingent of staff. So you have to look at this more closely. The industry is also worried. If you give this consideration only after the principal ordinance is passed, then you would still be like groping in the dark, and the industry will be quite worried. I hope you will give this consideration at an early stage. You have to know the figures because there will be a direct impact on the future requirements to be formulated. And I can also see that you seek to exempt PMCs providing services for standalone buildings. But I think this will be akin to the qualifications framework. And I'd like to see whether you are trying to exempt such companies, because if you seek to exempt these companies providing standalone service, then it may not be satisfactory. So I like to advance these views for your consideration, please, Director. Also, in the second round, we have two more members who would like to ask questions, Wu Chi-wai and Peter Chung. First, Deputy Chairman, Mr. Wu Chi-wai. Thank you, Chairman. I think we still have time, still 5 minutes for you. Thank you, Chair. I'd like to ask about the number of properties that can be managed by professionals. Do we still really have enough supply of personnel in the market? Normally, very often, PM is done in such a way that the benchmark is set on the basis of units. We don't look at the number of buildings, but the number of flats. So perhaps you can use this benchmark instead of 2 or 3 companies. Say if I work in really big PMCs covering 100,000 units, and the other manager may be working in a small company managing only a standalone building. But I cannot see in the bill where you mention a person working in 3 companies. Maybe I have overlooked this, but can you point out that clause to me, that a licensee should not work in more than 3 companies? And secondly, why 3, not 2, not 5? How do you set the basis? Secondly, grandfathering. Supposing I like to circumvent regulation by self-employment, then I would ask a company to just do cleaning for 1 building. And then I ask another company to do security service for a single building. And then again, I have another one looking after the lifts of that 1 building. And then electrical services and water supply services. I will ask 1 company to do it. And then another 1 company just working for this building in terms of structural safety. And all these companies will not be regulated. So if I do something like that, then I will not be regulated by the law at all. Is that right? Director, it is said that in the primary legislation, we cannot see where 1 tier 1 practitioner can serve only 3 companies. Now that would be in the subsidiary legislation. Once the subsidiary legislation is drawn up, there will be more information for members. When will you have the subsidiary legislation? It seems you are saying a lot of things will be in the sublet, but now we have no information. Well, exactly. I was asking for early indications. Well, whether or not something should be included in the principal ordinance, that can be discussed. Well, yes, I agree. And I know that before final decisions are made, we should have more communication. The detailed work is done in parallel. What about a timetable for the subsidiary legislation? Well, formally speaking, the Conservative reply is we would need the principal ordinance to be passed first before we draft the subsidiary legislation. But we are not going to do that. We are doing things in parallel. Just now you asked about companies providing stand-alone services that will not be regulated. Now, first of all, those companies will be regulated in that particular area of work by the laws that apply. Yes, I know that. And then in this PMS bill, these companies will not be regulated because we believe that in actual operation, if it is a large housing estate needing so many different kinds of services, then the OC or OI will not be entering into so many different contracts in order to hire the companies because it would be so difficult to manage. So on the ground, they would probably hire a professional PMC, which will make use of their subsidiaries or other companies in order to provide the different areas of service. Chairman, sorry, can I please interject? Because when we formulate the law, now, and I was asking you, if I really do something like that, does it mean that I can circumvent regulation? If the answer is yes, then if the exemption is still provided in the law without any other checks and balance, then somebody may very well say, if I can circumvent regulation like that, I would go for that because it will be easier for me. And this brings us back to Cap 344. You say owners will be protecting their own interests and they will have the big picture in mind and they will not cause chaos. But that is not what is happening on the ground. So if that is the reply from the director, I would be worried. I'd like her to clarify. If I self-employ and then I would engage 5 different companies to work on stand-alone services for the building I manage, does it mean that I will not be regulated? Director, theoretically speaking, you can say that, but it wouldn't actually happen on the ground. Well, you cannot presume the reaction of the market. So thank you. You are actually saying that what I'm saying is correct. It seems the director does not oppose to what you are saying. Next, Mr. Peter Chung. Thank you, Chair. I agree with what you just said, Chairman. One Tier 1 practitioner can manage 3 companies, and as Mr. Wu Chi-wai was saying, it is better to make use of the number of flats, or you can use the area because some buildings are not residential. Why, yes, because it's easier to do the sums. We'd like to know whether we have an immediate supply or sufficient supply of professionals. And at the same time, we can still make use of a standard, a criterion, and then we can have a longer transitional period. So we'd like to go for the best. And we should not say we should be flexible and lenient because we do not have enough supply of professionals. Because once the law and the code are made, you cannot always revisit them and change things. So I hope you would err on the side of strictness. I hope the transitional period would be longer just to make sure that we stand firm on our objectives. And just now the director somehow misunderstood me. 40,000 buildings, and 20% of which are managed by owners. In other words, there is management done. I was asking how many buildings will be exempted. I know that some buildings do not have any management done at all. Now, if buildings are in an estate, then they would be covered. But I'd like to know how many buildings there are that would be exempted. I'm not asking how many buildings are managed by owners without PM service. So I'd like to clarify that. Can I have a reply first?
Did you understand the question? I may not have perfectly understood what Mr. Cheung is asking for. You're talking about the buildings. There are about 6,000 buildings without any owners corporation or PMC and so on. Since they're not obviously these buildings are not managed professionally. Chairman, my question is very simple. How many buildings will be exempted? You said that for buildings which are self-managed by the owners, will there be people like Mr. Wu suggested, that is, they want to bypass the regulation and therefore through some means they will get themselves exempted, and that is a loophole. Basically, the criteria for exemption is that if the building is self-managed by the owners, there will be exemption. So the figures I gave you was the number of buildings which are managed by the owners themselves. But it doesn't mean that these buildings are poorly managed. There are, in fact, many buildings which are managed by the owners which are managed very well. Obviously, there are some where the management could be improved. Well, the director said that we have more than 6,000 buildings which are self-managed, and 8,000 by exemption. I think we put the two together. We're talking about 15,000 buildings which are self-managed, or 12,000, or 13,000. Is that the the accurate figure? According to the law, the word exemption has a specific meaning. What you were describing was not really exemption, but rather these buildings don't come under the scope of the supervision. What I'd like to know is that if there are a large number of buildings which are exempted, then we need to think carefully as to how we can ensure that these buildings are properly managed. We're not saying that they should be, managed. If there are only 1,000 or 2,000 buildings out of 40,000, it's a small number. If there are, 5,000 or 10,000 out of those 40,000, then that is something that we should look at seriously. Well, Chairman, to properly manage a building, we can't do it through the licensing. We're not saying that we can do that through the licensing regime. The Home Affairs Department is now have many initiatives to promote building management. We have professional, service we provide. That is, we recruit companies with experience in property management, and we would for buildings which are very old in age, or the rated value is very low, then we will provide them with the service free. We also have an ambassador scheme. We go to buildings which are not managed. We don't have the owners incorporation, and we will, provide training for people who would like to become ambassadors, so that while the building has not engaged a PMC, at least they will have some basic knowledge and liaise with the other owners so that they can better manage the buildings. For some buildings which want to conduct renovation, we also have another, scheme. And with the help of several professional institutes like the Institute of Engineering and so on, we will provide a free service to assist these buildings, so that when they need to undergo renovation, they can be given, the assistance from consultants and professional bodies. So by adopting a multi-pronged approach, we are promoting better management of buildings, and we cannot just rely just on this particular bill. Perhaps I can ask the administration to provide us with some figures. That is, how many buildings will be exempted according to what is proposed in this bill, and of these buildings, how many of them are self-managed by the owners? Director, I also would like to give you an example. That is, for the PMCs providing standalone services, there is a schedule, and the wordings used there does not stand alone at all. For example, for general management services in respect of property management, what does that mean? I think you should provide for a clearer explanation. Otherwise, there will be disputes as to whether or not company providing such services will need to be licensed. When you talk about general management services, what do you mean? When we scrutinize the bill later on, these are the areas which I'm sure members may be concerned about. Also, there is the question of exemption. We're talking exemption of buildings and exemption for companies providing services. So there are two types of exemptions here. Do we have any other members who would like to ask questions for the second round? Because we still have a third round. Ellen Leong, 5 minutes. I think the administration must understand that to manage a building or a housing estate is no easy task. For people who are willing to, dedicated time to do it are really conscientious. They are actually providing volunteer service, and these people are actually helping the administration. Without these conscientious volunteers, I'm sure the director will find it very difficult if you were asked to manage to build those buildings. So I hope that the administration would consider, would start with improving CAP 344 so that people are willing to work as volunteers. You would give such people more assistance. The director told us of her many schemes to assist these volunteers, but field experience have told us that very often the Home Affairs Bureau and the various units under the Bureau may not be willing to actually shoulder the responsibility. That is for people who are conscientious and willing to work as volunteers. I think you may probably know that when it comes to renovation of a building, we would hear serious allegations like people, for example, embezzling the funds of the owners and so on. Of course, the Civic Party always wanted the government to set up a special tribunal comprising of 2 or 3 judicial officers to do the task, so that these these volunteers will not have to bear two owners' responsibility. But for various reasons, and I don't know why, the administration said that we shouldn't do that yet. But even so, have you considered under, that is, you're proposing to set up a property management services authority. So within the PMSA, would it be possible for that authority to set up a data bank so that the experience, we can actually, share the experience of those who have the few experience, and also can you help the staff of the owners incorporation, including the chairman and executive members, so that when an owners meeting is being held and when they are faced with accusations and so on, then the PMSA can help them deal with those problems, rather than what we are seeing now. That is, when they ask questions, you're not able to give them definitive answers because the officials don't want to, take up the buck. And so I'd like to ask whether you would like to take the opportunity while we are amending the ordinance to help to provide more assistance to the owners in corporations. When we assist the owners corporation or the OC to better manage the properties, we have always been willing to assist, and we've come up with new programs and initiatives to help them. Mr. Leung asked whether or not in future the PMSC can have set up a data bank, and the data could be information shared by all the buildings. In fact, the Home Affairs Department already has a dedicated website for buildings, and we've also printed pamphlets which contain case laws highlighting the areas that owners may need to pay attention to. We already have such information available to assist store owners. In fact, such information not only assists property owners, it is also very useful when we train our own colleagues, and such information is already available. The PMSA in future, other than granting licenses and enforcing the law, will also play another role, which is promoting better management of buildings. And I'm sure the PMSA in future will also do something in that regard as well. Mr. Wu Chi-wai is next members to ask questions, and if no other members wish to speak, then we will finish our discussion after Mr. Wu has spoken. 3 minutes. I'd just like to follow up on the discussion regarding the subsidiary legislation. I think this should be our last meeting before the summer break, and I hope that the Home Affairs Bureau and the Department can submit the details of the subsidiary legislation. Otherwise, if we are contemplating to draft our own CSA, if the issues that we have in mind already in the subsidiary legislation, then we don't have to do it. If you enact a principal legislation and we're not clear about the subsidiary legislation, that would not be responsible on our part. So it's the 23rd of July, and we will only come back 3 months from now. So at least you should give us the framework for the subsidiary legislation so that we can proceed with consultation. And also in scrutinizing the principal legislation, we can also, have the subsidiary legislation as well. We attach a lot of importance to members' views. Talking about the formal legislative procedure, of course we will need to enact the principal legislation before we would table the subsidiary legislation. It is our objective that we would be able to enact the principal legislation in 2015, and then we will table the subsidiary legislation. Informally, we fully agree that before decisions are made, we need to conduct consultation and we need to have discussions. So this chair and before we formally table the subsidiary legislation next year, when we reach a critical stage in our work and we have any proposals ready, we will certainly discuss them with members through proper channels. Please be assured that there won't be that we will not table the subsidiary legislation to you without any communication. Okay, with that, I think we can adjourn our discussion today. There won't be a meeting in August, and we will inform members in due course about the date of our next meeting. Like Mr. Wu said, it will probably be after our summer break. So thank you. I'd like to thank the director and the administration for attending our meeting. And I'd like to thank members as well for your attendance. With that, we may now adjourn. Thank you.